Hey y'all, I'm Karen Mayer Cunningham, the special education boss. If you've ever felt confused, overwhelmed, or just plain frustrated at the 504 IEP table, you are in the right place. Every week, I'm breaking down the rules, the rights, and the realities of special education so you can walk into meetings informed, empowered, and ready to make real change. And whether you're a parent, a teacher, an advocate, a school-based member, or somebody who's just trying to do right by a student, this podcast gives you straight talk, real answers, and tools that you can use immediately. I'm not here to play politics. I'm not here to play sides. I'm here to train people who sit at the table and teach you how to follow the law, ask the right questions, and protect the rights of students. So go ahead and hit subscribe, share this with a friend, and you know what? Meet me back here every single week. We're not just talking about change. We're making it. Because when you know better, you do better. And when we get it right for the child, we get it right for everybody. Welcome everybody to our webinar. We are so excited to have you guys back. Part 2 of OCR complaints. Last time we talked about how to file an OCR complaint, what they cover, some of the areas they cover, and the specificity that they're looking for when you file a complaint. So if you haven't watched that, certainly go back and watch the first training because it's going to be foundational as we move into the second phase. So phase 2, what happens post-filing, right? What you need to know is the Office of Civil Rights, U.S. Department of Education, Office of Civil Rights is not a vending machine. It's not like we just throw it out there and they're going to go get them, right? The federal government has rules on civil rights under the U.S. Department of Education, Office of Civil Rights. We talked about what they follow up on complaints about last time. Let me just go over really quickly the laws that are enforced by OCR. So Title 6 of the Civil Rights Act of 1964, which prohibits discrimination based on race, color, or national origin. We talked last time. The 3 filings that I do around special education clients, for me, have been around race, retaliation, and discrimination based on disability. And number 2, the second thing that they cover is Title 9 of the Education Amendments of 1972, which prohibits discrimination based on sex. Section 504 of the Rehabilitation Act of 1973, which prohibits discrimination on the basis of disability. Number 4, Age Discrimination Act of 1975, which prohibits discrimination on the basis of age. Title 2 of the Americans with Disabilities Act of 1990, which prohibits discrimination based on disability. And then last, Boy Scouts of American Equal Access Act, which prohibits the denial of access to other discrimination against the Boy Scouts or other Title 36 USC youth groups in public education and public schools, public secondary schools, local education agencies, and state education agencies that have been designated open forum or limited forum. And you can certainly go to ed.gov and look up OCR. So this is information I'm just reading off of their site, and then we're going to go in more depth. So you filed your complaint. We filed either on discrimination based on disability. All my complaints that I file are discrimination based on disability and or retaliation and or race. And so certainly depending on the nature of what you're filing with them will determine which of those categories or multiple categories you choose. So I've sent in my complaint, and you can be filing on a number of things. You can file on behalf of your minor child. You can file on behalf of yourself. You can file on behalf of a group of people. And you can also file on behalf of, for me, I'm filing on behalf of a student I advocate for. I'm going to give you some generalities and kind of touch on some complaints that I file, what the process is. So I filed the complaint. I have Cindy Smith is the mother. So I have her sign a consent. Why? Because I am the complainant. As for my practice, I don't have my parents file because I want these processes to go as successfully as possible for people that I advocate for. But certainly you can file on behalf of yourself. So when I file, I am the complainant, and it's the student that I advocate for, or it's on behalf of a group of people. Why would it make 2 different things? A student that I advocate for is going to have specificity around a student that I advocate for that has a 504 or an IEP. When I file on behalf of a group of people, the only things that I've filed on for that are playgrounds, access, buildings, and so forth. And I'm going to go over both of those areas for you. So what's going to happen after I file? So if I filed on behalf of a group of people, so I go to Elm Elementary School in my neighborhood, and I realized that the playground is inaccessible. And we've had many videos on this. The flooring of the playground is not accessible, and it's pretty simple to figure out. Could you propel yourself in a wheelchair easily on that flooring? And usually the answer is no. And I would file on the playground. I don't need to have a student's name. I file on behalf of a group of people. There are other ways that you can file on behalf of a group of people, but that's the only way that I've ever filed for buildings, ground access to the building, the doors, those sorts of things, right? So when I file on behalf of a group of people, I do not need a consent form. I don't need to find every child at elementary school who is in a wheelchair, a walker, a stander, a gait trainer, AFOs, those sorts of things that would be impacted by an inaccessible playground. And again, that's going to be under Title II ADA. Those have been requirements since 1990. Who gets an exception? Say it with me. No one. No one. So when you're talking about playgrounds, and this is pretty much a generality, but unless the playground is in your backyard, literally, unless it's in the backyard and the public has access to it, it has to be handicap accessible. So there are playgrounds everywhere now. There are playgrounds at fast food restaurants. There are playgrounds at daycares. There are playgrounds in the airport. There are playgrounds at churches. There are playgrounds even inside of a mall. So there's great specificity. We're not going to do a training on that, of the percentages. It has to have handicap equipment, and the playground has to be accessible. And so that would be on behalf of a group of people. And so that's different because I don't need a consent form. The other one is for a student that I advocate for. I'm going to have the parent, Cindy Smith, sign the consent form. So I file the complaint, and there's a consent form that has to be filled out. If I'm filing for retaliation, I'm going to have two consent forms. One is going to be for myself as the advocate, because I will file that the student's civil rights were violated because the parent invoked their rights. And number two, they brought representation. So then I'm also giving consent to be part of that complaint. So I'm going to have myself fill out a complaint form and the parent. That goes directly back to OCR at ed.gov. OCR at ed.gov. You're going to email that back. Okay. If you don't email that back, or send that back, or mail it back, or fax it back within 20 days, your case is going to be, your complaint will be dismissed. Somebody has to have signed a consent form. Okay. Almost always, I've had times where it didn't go through, or I forgot to get it, or the parent hadn't sent it in. OCR is usually almost always kind enough to reach out to me, but they don't have an obligation to do that. So make sure that's done the day you file, that you have, if it's a parent you're representing, you make sure that those consent forms are sent in. So I have my client send the email to myself and then to OCR at ed.gov. And depending on where you are in the United States, it will go to a certain filing center. And so we talked about that last week. So let's talk about what happens afterwards. So they receive your complaint, they're going to go, they're going to tell the school district what happened, and everything is going to be a basket of puppies and rainbows. It's going to be super easy. That's not how it goes. So your complaint goes in. What is the timeline? That I cannot, I promise you, I cannot tell you. I've had complaints go in where literally in 2 days I get a response back. And we're going to talk about the response that you get. And I've had a complaint go in and I haven't heard from anybody for this notification process for months. And so what is the variable? Complaints and investigators. How many complaints are there and how many investigators are there? So there's about just under 600 investigators currently in the U.S. Department of Education Office of Civil Rights for the United States. Depending on where you are, there's going to be more complaints. So in our district, in our region, it is Texas, Louisiana, and Mississippi. 3 not really good sometimes at being compliant special ed states. And in Texas, we have 605,000 children have an IEP, and hundreds of thousands, millions of kiddos have a 504. So if you're in Wyoming, your complaint might go through a lot quicker because there's less people. It's the lightest populated state in America. So different areas are going to have a different number of complaints that they are dealing with. And so I cannot give you a timeline. What I can tell you is going to take a while. If you are in a rush and you have an emergency situation, you're probably not going to be happy with the OCR complaint process because it is tedious. It's very detailed, which is what we want, but it takes quite a while. Okay. So we've sent it in, we've sent in our consent forms, then what happens next? So then you're going to be contacted by U.S. Department of Education, Office of Civil Rights. And so this is a general email that I will get. Good afternoon. Thank you for submitting the above referenced complaint and consent form to the U.S. Department of Education, Office for Civil Rights, OCR. I have been assigned to handle this complaint. I've been assigned to handle the complaint. I would like to speak to you over the phone to collect some additional information from you regarding this matter. And then they indicate how they want to be responded to. So in that letter, it's all in the email. It's going to be an email to you. It almost always says complaint call, complaint clarification. Nothing's been open. This is just they've received it and they want to ask you some questions about the complaint. Now, depending on the investigators, different investigators do things different ways. I've been on calls before that were 7 minutes long. And then most calls are going to be at least 30 minutes, knocking on an hour, right? So what happens in those calls? So the first thing that happens is you want to capture, they will have assigned you a number. They will have assigned you a number. These numbers are public record. And so you'll keep that number with that complaint. If you're an advocate, you'll probably have several complaints at one time. I probably at any point have 100 complaints for families. And it will just say, we've received your complaint. It's not going to say New York ISD, Las Vegas ISD, Dallas ISD. It's going to say, we've received your complaint. And if you are an advocate, you're going to have a lot of complaints being filed. So you want to make sure that you're sure which complaint that is. Often you'll be filing on siblings. You'll be filing on the same school district. So you want to make sure that as soon as you get that notification number, almost always, but not always, they will have in parentheses the school district that you filed on. And depending on where you are, you might have 10 in one school district and you might only have one that you ever deal with. But you want to make sure you captured that number. That 8-digit number will be your number from beginning to end, whatever that beginning or end is. What is the longest complaint that I've had open? I have a complaint that was opened, not this part. Opened is coming in the next training, October 2021. So it was opened 26 months ago. It's a very long time. And it's still in process for a number of reasons. Okay. So you will have that call. And so sometimes when you get this email, they will actually ask you for documents right then. And as we talked about in the last training, there's a line under the form that says two things, right? Do you have documentation to support your allegations? Of course you do. If you don't complain to the OCR, they are just like, think about it in a court system. I'm not an attorney. I'm not giving you legal advice. But if you go into court, they're asking for evidence, right? And what is that evidence? Those are things that you can photocopy, you can enter as documents. So you can know that the OCR is going to ask you for documentation. So before you file, and you're going to file on a 504 or an IEP, that you have those current documents ready. It's literally, depending on the investigator you get and just however it hits, they might say, good afternoon, Ms. Cunningham. We've received your above complaint. Please send me the IEP document. And you need to have that. You need to have that ready to go because whenever they want it immediately, and you need to be efficient. Whenever they want the 504 document, you need to have that immediately. If they want the IHP, individualized healthcare plan, you need to send that immediately. So whatever you're alleging is going to capture in writing the violation. You need to have that ready. If you have retaliation emails, you need to have that ready. If you have evidence that supports race discrimination, you need to have that ready. Me saying it happened, you don't need to do that. That is a waste of your time. This is not the he said, she said business, right? And when you get on the call, and I don't have it word for word, but the first thing that they're going to go over is they're going to ask you some questions. Do you understand what the OCR does? Do you understand their position? They're going to tell you that this is just a phone call. We haven't made a determination. We haven't opened the complaint or not opened the complaint. We're gathering information. So this initial call is to gather information. A lot of people are like, oh, they called me. They've opened it. They haven't. They're gathering information. Now, you must have had enough information that it was worth gathering information. And I can tell you from years ago when I started filing, sometimes I would just get letters dismissing my complaint because even in my complaint, it was so poorly written, there was not enough evidence to even do an opening phone call, or it's not under the umbrella of what they evaluate. And it would take me 100 years to describe everything that they might evaluate or not evaluate. but let's talk about the things that they don't evaluate. Okay? So OCR evaluates the written information that it receives to determine whether or not it constitutes a complaint that's subject to further processing. So all of these steps are part of the processing. If so, OCR determines whether it can investigate the complaint, makes this determination with respect to each allegation in the complaint. For example, OCR must determine whether it has a legal authority to investigate the complaint. That is, whether the complaint alleges a violation of any of the laws OCR enforces. OCR also must determine whether the complaint is filed on time. Generally, a complaint that's not filed on time will be dismissed, or there's not a request for a waiver. OCR will decide whether to grant the waiver. In addition, OCR will determine whether the complaint contains enough information about the alleged discrimination to proceed in the investigation. If OCR needs more information to clarify the complaint, it will contact the complainant, and the complainant has 20 days to respond to OCR's request for information, unless the complainant has requested additional time to provide that information. That's a pretty tight timeline. It's a pretty tight timeline if you're busy in your job. So you need to have all of those things ready. Some of the reasons OCR might dismiss a complaint include OCR does not have legal authority to investigate the complaint. Next, the complaint fails to state a violation of one of the laws that OCR governs and enforces. The complaint was not filed timely. 180 calendar days is very short, right? And the waiver of the timelines required was not granted. The waiver of the timelines was not granted. The allegations raised by the complainant have been resolved and are therefore no longer appropriate for investigation. A signed consent form is required to proceed in the investigation, and the consent form was not provided. Okay. So this is all of this is in the they're evaluating whether it's going to rise to the level of a complaint. They're evaluating whether what they have will rise to the level of a complaint. One of the first things they're going to say to you over the phone is, we are the federal government. We are not on your side. We are not on the school side. We are simply fact finders, and we are gathering information. So who are fact finders that you might know of? Judges, hearing officers, and they're looking for facts. And I know that most of us know each other from social media, and we have a lot of opinions. But in the legal space, all that matters at the end of the day are going to be facts. And so you need to make sure that you have those and that you are clear with them over the phone. Here's what you don't need to talk about over the phone: your feelings about the situation. Stick to the facts, and you're going to have more efficient and successful evaluators evaluate your complaint. Because if it's outside of the facts, it's not something they govern. They do not govern feelings. They don't govern your perspective. They don't do any of that. They determine whether the facts are in fact a violation of the scope of what they oversee. So the call could be an hour phone call. I have only in all of these years ever had one Zoom one time. I was like, oh, I think that I know what they all look like. They're all very nice. They're very respectful, but they are business. They're not going to go, we knew it's wrong, Karen, or we love the school district. There's not going to be there's none of that. This is not cable. This is not HBO. This is not sensationalized. They're not going to provoke you to do something. They're not going to tell you, way to go. There's none of that. So if you are expecting, for lack of a better word, a read, a feeling on how it's going, that's not going to occur because they're federal attorneys. That's not their job. Their job is to simply gather information in these processes. So this is a call to clarify. Now, this evaluator does not make the decision whether or not to open the complaint. The evaluator you're talking to does not make the decision whether or not to evaluate the complaint. They take the information they have gathered from you, maybe the 504 document, maybe some emails, maybe some information that you have that supports retaliation, and then they take that back to a team. I don't know who the team is, but they take that back to an evaluation team. And then those team members look at it in a multidisciplinary way, which is good, right? That's what we want. We want it to be solid and right. And so after that is when you're going to get a notification letter or a dismissal letter, right? And so a notification letter simply says they are notifying you that the U.S. Department of Education, Office of Civil Rights, has determined, based on your complaint and your allegations, that it will be opening all or some of your allegations. it will be opening all or some of your allegations. So on the call, they're clarifying. So, Miss Cunningham, you said that ABC Independent School District did not provide Billy Smith extended time in math, science, social studies, and reading. Is that your allegation? Yes. And you were literally just repeating your allegation. And they will say things like, how do you know that? You need to have an answer other than, I just feel like it didn't happen. There's no need to say anything that has the word feel. How do you know that? I know that because my student had to leave the class and he wasn't finished and he didn't get his extra time. And the teacher said, when you're done, you should have finished on time. You need to have information that supports that allegation. We're not sending people down a rabbit trail. What information do you have that proves that, right? So let's say one of our allegations is that Billy Smith tests weren't chunked. How do you know that? I would say because if his tests were chunked, then I would actually see that different product, right? Chunking looks different than the tests that we give to the other students. And I would have seen that on his graded work. So when you're prepping your client or you're thinking about filing, what do I have that's literally evidence that I could provide the federal investigator? And then I would send them back a test, which you can very well see was not chunked. Maybe a test was supposed to have 3 questions instead of 3 answers instead of 4 answers. Here's the test that he has. It has 4 answers, right? And so I love school districts. I love teachers. I love staff members. And so one of the biggest misconceptions out there is that you are not responsible as teachers for implementing accommodations, and you are. You absolutely are when it comes to complaints being opened. And let's go over a notification letter. So I've had the call, I've clarified that. At the end of the call, he's going to say, is there anything you want to add? Is there anything about that? He'll repeat what your complaint was and anything he clarified. And then you wait. And usually it's going to be within a couple of months. I don't usually have it come out the next day. If I haven't heard from them after a month, this is just me. You can certainly do what you want. If I haven't heard from them on a month, after a month, I will say, is there anything that you need from me pertaining to case 05249132? And they'll say, no, we have everything we need for now. Okay. I don't recommend that you call them. I don't recommend that you irritate them. Certainly, it's my experience, they're doing their job. But I certainly think it's fine. Certainly, some people will say call once a week. I don't do that, but whatever you think is best. I email once a month when I'm looking for updates. Okay. So then you will get either a dismissal letter saying that they did not find based upon your phone call, your email, or the information that you provided them that they are able to open this complaint for investigation. And then they'll tell you the reasons why, which we just read off, which are listed on the OCR complaint processing procedures under reasons that they would dismiss it. So let's say that they're not going to dismiss it. Then what happens? Then you get an email with a notification letter. And it simply says, and I'll just give you some generalities, the notification letter. Now, the notification letter goes to 2 people immediately at the same time. Immediately at the same time. The notification letter goes to the complainant. So that's going to be me as the advocate, or you if you're filing on behalf of your child or somebody else. And it goes to the school district. Now, the good news, I think, for me in the federal filing is the school district is never notified of anything if they don't open the complaint. So let's say that you opened the complaint, and when I started doing complaints, they were very passionate. They were very narrative. They didn't get opened. They didn't have facts in them. So I would just get a letter saying, Ms. Cunningham, we are not going to be able to open this complaint, and they would list the reasons why. This said school district never knows about it. They never know about it. Okay. If they do open the complaint, it's called a notification letter. And this is all done by email. In the olden days, before we were all sitting here on the internet, you would get an actual letter. It's going to say the United States Department of Education, Office of Civil Rights, has their big seal right there, and it will say whatever region you're in. I'm in region 6, and it will say the states that they govern. Our region is Louisiana, Mississippi, and Texas. It will have my name, the email, and it'll say my name and I'm just going to give you an example. On whatever date, the United States Department of Education, Office of Civil Rights, Dallas office received your complaint that you filed against ABC School District, alleging discrimination on the basis of disability and retaliation. Specifically, you allege that the district discriminated against a student, and then it puts the student's name, with disabilities and discriminates against other students with disabilities, and the school district, the school, by, and then the following. And here they list some of my allegations, and I'm going to read them to you. Number one, treating the student differently from non-disabled peers by A, denying the student entry into the school until XYZ date. B, requiring the student to be placed in a plastic stroller with a five-point harness to enter the school. C, compelling the student to use a plastic toilet on the floor without plumbing. Number two, improperly restraining the student in a plastic stroller and gait belt. Number three, failing to implement the student's IEP. Number four, not effectively communicating with the student by failing to use the student's voice output communication device, VOCD. Number five, retaliating against the student based on your advocacy by threatening to disenroll the student. And six, maintaining inaccessible entrances, bathrooms, classrooms, as well as inaccessible playgrounds, smart boards, motor lab at this location. Okay. It then says OCR enforces, and it lists all the things that they enforce. The district is a recipient of public entity. Therefore, OCR has jurisdiction to process this complaint. Under 504 and Title II. Based on the information you've provided to this office, OCR has determined that it will open your complaint for investigation. Please note the opening of the complaint of a complaint allegation for investigation in no way implies that OCR has made a determination with regards to its merits. During the investigation, OCR is a neutral fact finder, collecting and analyzing relevant evidence from the complainant, the recipient, and other sources. So who's the complainant? I'm the complainant. Who's the recipient? The public entity that receives federal funds that I filed on, and other sources as appropriate. OCR will ensure that its investigation is legally sufficient and its disposition of the allegations under investigations in accordance with the provisions of OCR's case processing procedures. The district has been informed of your compliant allegations, and OCR has requested documentation and information from the district. OCR will contact you and the district regarding next steps in the resolution process after it receives the district's response. Please note, the OCR's case resolution process includes mediation. Mediation allows the parties an opportunity to resolve the complaint. If both parties are willing to this approach, the OCR determines if mediation is appropriate. That's your decision whether or not you want to participate in mediation. OCR will facilitate settlement discussions between parties and work with parties to help them understand the legal standards and possible remedies. More information about the mediation process may be found at the OCR complaint processing procedures. So you should always have a current copy of the OCR complaint processing manual. The last one came out in August 2022. You can print that off on OCR website. Please let us know if you are interested in mediation. Please be advised that the recipient, that is the school district I filed against, may not harass, coerce, intimidate, or discriminate against an individual because the individual filed a complaint or participated in the complaint resolution process. If this happens, the individual may file another complaint alleging such treatment. Under the Freedom of Information Act, FOIA, it may be necessary to release this document and related correspondence and records requested. In that event, OCR receives such a request, it will seek to protect, and to an extent by the law, personally identifiable information, if released, could be reasonably expected to constitute an unwarranted invasion of personal privacy. And so that will be the investigators. And that's a really robust complaint that I have that was quite extensive and egregious with the school district. But I want to stop at that place because we're going to unpack the rest of it once the school district receives their letter. So that is the process between the evaluation process and either a dismissal letter or a notification letter. That is the letter that you get. That is not the letter the school district gets. The school district gets another letter that we'll talk about in our next training, and it requires action on their part in a very quick, robust time. And so I think it's very important to remember if something happens after you file the complaint, say something crazy happens and the school district behaves worse towards you, I want you to remember that last one of the ending paragraphs, which says, as a reminder, the recipient may not harass, coerce, intimidate, or discriminate against the individual that filed the complaint. If that occurs, if you feel like there is a retaliation after that or more discrimination, you would have to file an additional complaint. Remember, the complaint solely encompasses those allegations that you made when you filed and that you clarified during the phone call. Okay. So that was a lot of information, a lot of words. So we want to open it up for questions.
This one is a comment. It says, oh my God, this is exactly what I'm dealing with, but the school is grandfathered in and they won't make accommodations, even though I found multiple grants the district is eligible for. They say that my son is fine not using his walker on the playground, but he has fallen 6 times in 2 months. And I also found out my 5-year-old not at school.
Okay, so I don't know what you mean by he's grandfathered in. So there are stipulations for certain entities, but everybody has to be ADA compliant, which is under OCR. That's what Title II is. It started in 1990. So I don't know, and maybe you can ask again in the comments or whatever you're asking, who told you something was grandfathered?
Let's hope that she clarifies that. What should be included in a parent consent form?
Oh, that's a good question. So the parent consent form it's going to ask for the student's name and then you sign it. What's important is you put the student's name and then I have my clients put their name, right? Because sometimes some of us don't have the best handwriting and that's the only form that goes in. So it's supposed to be printed and then you sign at the bottom. A lot of times our parents have different names than the student for whatever reason. So on the top form, I will have them put their full name, the school district, and the student's name. The rest of it is giving you the 2 choices at the bottom is you give them permission to disclose your information or you do not. If you do not give them permission to disclose your information, they're not going to open the complaint because your information will be part of a FOIA request if the school district did it or if anybody else did it.
Perfect. I'm a mom who filed for lack of 504 unfair treatment in comparison to another child, inaccurate or fabricated information, etc. If I did it wrong because I am afraid I didn't do it right, can I refile if they say no?
You can always refile. You can always refile. You can clarify things. And here's the thing, they'll either dismiss it or open it. When they do that call, right, to see if we're going to go in the next process, go from evaluation to notification, they're asking you for clarification. Did we get this right? And then I will ask them, most investigators are going to make you file another complaint, even if it's in the same timeline. But if you can always refile.
Perfect. I have filed. I was told that the doors do not have to be handicap accessible like the switch to the school building. My kid can self-propel his wheelchair or walker, and his nurse carries his medical bag. I've thought on if I can get this fixed.
So who is telling you when you say somebody said the doors don't have to? So did you file a federal complaint or you filed a state complaint?
Okay, I'll let you know if she responds. We'll go
And
ahead.
so let me just respond to that as well. No, we don't have to be like we're at Target or we're at Cabela's where you press a button and the doors open. However, there are other guidelines as well. You and I know how heavy school doors are, right? Have you ever tried to go in one, they are so heavy. And especially since safety issues have come into play at schools over the last 15, 20 years, they're really heavy, right? So the intention of an individual, this is for individuals, right? This could be if your grandfather was going to visit your son on Grandparents' Day at the school. They have to be handicap accessible. What does that mean in a short version? That means I don't have to get somebody else to help me access the building. So there's this misnomer because the nurse can open the door. The nurse doesn't have the handicap. The individual that has a handicap, it has to be accessible. So most school doors have a buzzer, right? Because I know, so we went to 100 IEP meetings, and then you wait for somebody to, hello, and then they're like, what are you here for? I'm here for the Fun Fest IEP meeting. And then the first one unlocks, right? And then usually the second one unlocks. You have to have handicap accessible doors to the building. It doesn't have to be every.
I'm so sorry. My child was expelled. I filed an OCR complaint. If they open the case, what happens next? And after everything is done, can I sue the school for my lawyer fees if I win?
So again, I don't know that your child being expelled is going to be under OCR. So OCR, usually what I'm talking about as it relates to special education is, were there accommodations not delivered? Was their IEP not implemented? Were their services denied? Was there retaliation and or was it race? Obviously, those are some generalities. I don't know why your student was expelled, but if you believe that it's discrimination based on disability, it was discrimination based on race or discrimination based on retaliation, then you could file under that. I've never filed for a child being expelled.
Okay, perfect. And then the one that asked about the door button, she said she filed that with OCR.
Okay.
But
And
it
they
was so heavy and she was wanting independence.
and again, sometimes we're not specific enough. There's no requirement that every door that is accessible. So you have to say where people enter the building in the morning. We enter an elementary school in several. There's usually the door that's for the 3 to 5 year olds, or even a kindergarten door. Is there a door that's generally accessible that would meet those standards? So there's even an app that measures how high up is the door. And sometimes you could have been right, but your filing wasn't specific enough. There is, back to what I was talking about, the weight of doors, right? There's a percentage that you should be able to open a door. It's not a 50-pound pull, right? If you don't have enough language around that, there's a possibility they didn't open your complaint. They're only following your complaint. They're not going to go, hey, Alicia, you need to add 2 more words to your complaint. They're not going to do that, right? They're not representing you. There might be just a few words that I'm sure they could have told me years ago in my complaints that would have adjusted it. I just didn't have the knowledge base yet. So if I'm filing a complaint like that, I'm going to say that here's what I'm going to say, because it's never just the door, is it? It's never just the door. So I'm going to say that the school district failed to maintain accessible entries, accessible bathrooms, accessible classrooms, handicap tables in the classroom, handicap tables in the cafeteria. And an opening at the end of a table is not necessarily handicap accessible, right? I'm going to say that the sinks are not handicap accessible. The soap is not handicap accessible. The paper towels are not handicap accessible. You literally give them the allegation. They're not going to say, would you ever think about this? Did you ever think about that? What about the water fountains? They're not going to do that. You literally have to think about those components in the building that wouldn't be accessible. So for that, obviously there's an amazing website, the Americans with Disabilities Act. There's great specificity on that site as it relates to buildings, right? It wouldn't matter if it was the post office, it wouldn't matter if it was the courthouse, wouldn't matter if it was any place that is accessible to the public. What are those requirements? Let's talk about that. So I will be in a meeting with the school and they will go, Karen, we're handicap accessible. Otherwise, they wouldn't have let us open the school. That's not true. That is so not true. No city is being told by contract workers all the specificity that's required under ADA. There's no ADA police going out knocking on doors. You would think that it was a requirement. Certainly, they're going to meet city standards, right? You're going to have so many bathrooms based on population, so many handicap stalls. But the city is not coming out measuring if somebody in a wheelchair can reach the paper towels. That is not what's going on. ADA is going to give you great information about that, and that will really help you with filing accessibility for buildings as it relates to schools.
Thank you so much. Can you file for retaliation if it's just because we as parents advocate, but we don't necessarily have an advocate or a lawyer? I'm an SLP, but it's for my own child.
Yes, you file in retaliation because you invoked your rights, right? So it's two things: because you invoked your rights or because you had representation, right? I invoked my rights and the school retaliated. And they're going to say, how did they retaliate? They didn't let him go to resource. That's not retaliation. Retaliation is a number of things, right? School districts sometimes send some really not nice emails. They stop meetings, they turn the meeting off. And I think it's really important to remember that we all have all of that recorded right now. They send you a prior written notice and say all of these things happen in the IEP meeting and none of them happened. You have emails from the school saying you are difficult to work with and we are not going to work with you. You would be surprised at what people just email parents. You would be surprised what schools say to parents over the phone, right? I always tell people that I'm training anywhere, whether I'm doing professional development at a school or whether I'm training you amazing advocates, you can be certain that when you're talking, somebody's recording you, right? And so I've had schools call a parent, and the parent is recording the call, and the schools are quite transparent with the parent about what happened on the phone call. That's a recorded call, right? And so in almost all states are a one disclosure state. What does that mean? That means if I'm talking to Alicia over the phone, I have a 70 IQ or higher, these are generalities, and I'm an adult, and she has an IQ that's 70 or above, and she's an adult. Neither one of us are compromised cognitively. As long as I know that I'm recording, I don't have to disclose that to her. Dojos, text messages, all sorts of stuff that happens, right? Voicemails that we leave parents. Those are, you need to really think about what you're saying to your parents. And I know that 99% of people at schools are amazing and love kids and are doing the right thing, but there are people that are not.
Amen to that. Okay, where do they get the consent form that needs to be sent in?
Sure. So when you hit send on the OCR submit form, it actually is an attachment at the bottom, or you literally can Google OCR complaint consent form. It's on their site.
Perfect.
Yeah.
And when should an OCR complaint be filed versus pursuing a due process? Or should both an OCR complaint and a due process be initiated when the student's IEP is not being followed?
So for purposes of this training, we're talking about OCR. That would be a personal decision. What I can tell you, any of the 6 dispute resolution options that you choose to exercise, only do one at one time. Whether it's a state complaint, a grievance, a written complaint, a due process, a mediation, the first thing it's going to ask you, are these allegations opened by another agency? And the answer is going to be no, because that's the agency that you chose to look at your concerns. And they all have different parameters. OCR, 180 days. In our state, a state written complaint, a year. In our state, due process, 2 years. They all have different pros and different cons, but a due process and an OCR complaint are two totally different entities. A due process is a hearing in front of an administrative hearing officer and its court.
Perfect. And then these both are around mediation. One is, do they recommend it? And the other one is, if you choose not to participate in it, does that negatively affect your complaint?
So I will say it does not negatively affect your complaint, but we're going to talk about mediation in our next training. It's certainly your decision, but we'll talk about what the pros and cons are of choosing mediation, because that would be at the next step of the process where we're moving towards resolution. So we'll talk about that in the next training.
Perfect. Someone asked if you could file OCR in your local jurisdiction, such as the county district court.
No, it's a federal complaint. So you're filing it in federal, as a federal region. So there are, what did I say last time? 13 or 12 regions, and they house somewhere between California is its own region. Way to go, California. Up to 5 states. You can look that up on the OCR complaint process manual. It has the whole United States, and it will tell you what encompasses. Some of it's odd because sometimes you might be getting an email from Pennsylvania, but you're in Kentucky. But those are the states that it encompasses.
Thank you. Who has the burden of proof? I've always been told the parent or complainant doesn't have to prove the allegations. The district and personnel must prove they did it. Is that correct?
If you're the complainant, you need to prove that what you have is enough information for the OCR to open it. And we'll talk about what is the obligation next time, what the OCR is asking from the public entity. But their job is to refute your complaint, right? Karen said we didn't provide chunk tests. Here are 10 tests that are chunk. Karen said we didn't provide special ed teachers in the science class for in-class support. This is Ms. Smith. She's been his in-class support co-teacher. Here's her license from Wisconsin. They're going to respond, and they're going to respond through their attorney. So you need to make sure that you have a weighty complaint and that you have the ability to refute whatever they come back with.
Can you give an example where OCR didn't give the outcome you expected?
It happens, right? It's a process, and we're going to go through more of the next steps. And it's not about the outcome that I expected. Sometimes I don't have enough documentation to prove what I know to be true, right? Sometimes I've had a teacher say this and this happens. And when you get in the complaint process, these miraculous documents appear from the school district, right? It's not my experience very often, but there are many steps in the process. One of the steps that the district could participate in is called entering into a 302. And so what does that mean? They could just immediately get my complaint and go, you know what, Karen, I'm the superintendent. I am signing that I'm going to enter into a resolution with you. Oh, okay. And we'll talk about what happens next. So some of them happen very quickly. I had a district one time that they signed a resolution form with the OCR because they're the ones signing the form together. And then we'll talk about what happens after that. The outcome is determined by the perspective of the investigator doing the complaint. Sometimes in your complaint, it then gets handed off to a different investigator. So I think they retire or they move to another region. I'll have Cindy Smith is my investigator, and I'll get an email. I just got an email last week from a complaint that I opened October 2022. And she said, the investigator has given this complaint to me and I'll be taking it going forward. Okay, I can't do anything about that. They all have to shift their caseloads. And so I wish the process was quicker. I'm very thankful for the Office of Civil Rights. I'm very thankful because if you have a state that really struggles to be special education compliant, like my state, Texas, we rank in last place. I find sometimes this is a more effective vehicle to get the outcomes that I need for kids.
Perfect. Can you explain consent decree?
Consent what?
Decree?
Consent decree? I don't know what that means.
All right, maybe they'll elaborate.
Yeah.
Okay, I've been advocating for my son. I am a teacher at his school site. My wages were deducted. Would this be considered retaliation?
Your wages were deducted from, I don't know what that means.
I don't know. Maybe she will elaborate also.
Yeah.
Okay. My OCR.
So let me just clarify. So when I'm talking about retaliation as an advocate, I'm talking about the parent invoked their right or they brought representation and the school acted horribly and did awful things that were clearly procedural and ethical violations.
Perfect. And then I just want to let our little friends know, I can only see 2 or 3 questions at a time. So if you're breaking your question up amongst multiple comments, I can't see them all. So if you can just submit them all in one chunk, I'll read the whole thing.
Do you want them to chunk their complaints?
I need them to chunk it, please. Okay, my OCR complaint was dismissed because we did not check off the waiver box. Do we need to check the box in the event that it arrived late? We calculated we filed on the 180th day.
If it's outside of the timeline, you didn't ask for a waiver or the waiver wasn't granted, they're going to dismiss it. Yes.
Okay, I filed a complaint on October 31st. I have received clarification emails twice, but no phone calls. The last one was December 4th, where the attorney from OCR set forth elements of my complaint and asked if they were accurate. I replied with a clarification and I've heard no response. Is it best to wait until January 4th to check in?
So you can check in anytime. Almost always, thfor me, they've asked me for a phone call. And obviously, I've been doing this for years with them. I'm pretty standard with them. But depending on who the attorney you get is, they might say, Ms. Cunningham, please do these 8 things for us. And so I will attach the documents and answer them briefly. My response is, I'm happy to do a clarification call. Because I don't find, and maybe you're really good at this, I'm not, I'm a talker, not a typer. I find that when I type something out, usually somebody has questions around what I typed out. So I offer both of those things, right? So if they want to call, we can do a call. That's my first wheelhouse, right? But if their clarification about your complaint is written, then I'm going to respond written. And then I'm going to say, additionally, I'm available for a phone call for specificity around my responses. You're welcome to email however often you want. I don't want to be a pest. But simply the email is just checking the status on this complaint. I'm checking in the status. And they're usually very efficient and say, no new updates at this time. And that is what it is. So I wouldn't say why. You just have to respect them and say thank you. But I would do once a month.
Okay, perfect. All right, this one is one of the ones that's multiple comments, so I'm gonna try, but she was the one that was talking about how she was looking into grants and stuff to bring the playground back up to compliance. So here's the rest of the story, okay? My son has cerebral palsy, has AFOs, and does have a walker, but they keep sending pics of him not using his walker because the wheels don't move on the ground at the playground. I contacted the superintendent and the school board and the director of special education and the school principals and the teachers. Also made suggestions to make the playground safer for all children. Says anyone can fall when it rains. My son has CP and he isn't stable. That was one comment. And then at the bottom, she said, I had asked about the playgrounds not being ADA compliant. I tried talking to everyone, gave grants to the school, the superintendent, but they said because no modification has been made since 2012, they are grandfathered in. So they don't have to be ADA compliant. They're having my son not use his walker. He has CP and braces and says he's doing fine because his walker doesn't move on the playground. They say the new IEP doesn't have playground accommodations anymore because he is able to use his walker.
So I would never, listen to me, ask anybody at the school to fix their playgrounds. Nobody at the school is unaware that they are not ADA compliant. You won't pull up to a school and there's not handicap parking. You won't pull up to a school and there's not handicap ramps. You won't go into a school where there's not handicap bathrooms. So this is not news. So you can talk to the superintendent's friend. You can talk to whoever you need to. I've found that to be futile and frustrating. Either the playground is accessible to anybody. If I was in a wheelchair and wanted to access the playground on a day in my neighborhood and I can't, it's inaccessible. Has nothing to do with if it's inaccessible to your child. Public property has to be accessible to any individual with a disability. So if a 90-year-old was there in a wheelchair, is it accessible? And the answer is either yes or no. There's no movement, right? Do we have an inch for every foot of rise? So there's great specificity. So I would greatly encourage you to look at the ADA's website. Their requirements are pristine for almost 24 years now. But if you ask people, they're going to tell you we're good. Nobody is grandfathered. That's not a thing. That's not a thing. Maybe if it was Benjamin Franklin's playground and it was in a museum and it was roped off, but if it's open to the public, then All Americans with Disabilities Act says it has to be equal access to people. Now, every piece of equipment does not have to be ADA compliant, but the floor needs to be wood, tile, concrete, or asphalt. So when I go to Missouri and they have ground up coal on the bottom, or when I go to Louisiana and they have ground up foam, or when I go to Texas and they have bags of mulch. So I don't waste my capacity with schools. I did that for years. It's ridiculous. If it was important to them, they would fix it. But there's no school board that's unaware that their playgrounds are inaccessible.
Okay, perfect. There are people that are asking questions that are outside of OCR. Just want to let y'all know I'm going to ask the OCR questions first. What are typical outcomes of a successful OCR complaint? Is it monetary? Do they fix the problem? Only have to do quote unquote training like most SEA complaints?
So what's going to happen is you're going to get a check for $1 billion and a lifetime supply of free hairspray and some rice-a-roni. So there's no such thing as typical. It's based on a number of things. It's based on if you're a good negotiator, right? And we're going to talk about that in the next training. But the two things that I file on, and I would recommend that you file on this, is that when I'm filing against a school district, I want two things. I want number one, always, I want the district and or its staff. Obviously, it's not a staff issue. If the playground's not accessible, that's a district issue. I want the district and the staff trained on their duties, obligations, and responsibilities under ADA 504 and Title II. If it includes other things, then I will say that. The second thing that I want is compensatory time for the disabled individual had the violation, to return them to where they would have been had the violation not occurred. Let me repeat that. So compensatory time for the student with a disability to return them to where they would have been had the violation not occurred. Those are both very general statements, and we'll talk about it in the next training is how I tighten that up. And I've had OCR complaints. I've had one that was, and the settlements aren't sealed. So unlike mediation at the state level, there's nothing sealed about a settlement, but those are certainly the family's position if they would want to share that. I've had OCR complaints, resolutions that went 6 years. What I required and what we settled was to be delivered by the school district over 6 years. I've had settlements that included the district paying for services for the student with a disability. Nobody's gonna just write you a check. I'm emotionally distraught, right? So when I file, I'm asking for compensatory time to the student that is disabled. What would that relief look like? That relief might be counseling for the family, depending on what the filing is, depends on what would make it. I'm asking for two things: what's going to make it right and what's going to keep it right. And those have to do with specificity and negotiation. You have to remember whether it's an OCR complaint, a mediation, a state written complaint, or due process, they are still going to make you go back to the table with the same people that you are alleging caused the problem and need to work that out at the table, at a settlement, or in a dispute resolution session.
Perfect. Thank you so much. Does the school have to be handicap accessible even during construction? The school has been under construction for 2 years with no handicap accessibility.
Is the school open? If the entity's open, if Target's open, if McDonald's is open, if elementary school is open, if the Houston airport is open for business, it has to meet the requirements of ADA.
Perfect. If the superintendent emails the parent whom works for the same school district that if they don't stop emailing the school about the child with a disability, she might be fired, would that be retaliation?
I think it would. That's fantastic. It's amazing how people just lose their mind and just start typing. You would like, what? Yeah. Might be fired. And there you
And
go.
it's in writing. They just made it easy.
Yeah. I
Yeah.
have a lot of things in writing. You're like, oh my goodness. Yeah.
Yeah.
In writing or recording.
Yeah. Okay. So what happens if they open the investigation and the school does not want to work with your resolution?
So that's another step. So we open the investigation, and then after that, we have different things that are going to happen. The OCR has determined XYZ. OCR determinations are going to be in the next training.
Okay. I like this question. She's just starting to learn about all this process. Is this complaint process the first part of a mediation process?
You can mediate with somebody at any point. I'm a certified mediator for the family courts outside of special education. I can do a settlement with the school district at any point. I don't need to have a mediator. I just need to have some people in the room that can make decisions that are sane and are student focused. Mediation is a totally different process, whether it's at the state level or a federal level. But as it relates to mediation, we'll talk about that in the next training.
Perfect. The OCR has closed the monitoring of our resolution agreement, but the school has not continued to honor that agreement. He is supposed to be getting 30 minutes of tutoring daily, but they have no longer been doing it due to what they say he doesn't need it. Would you just notify the OCR or make another complaint?
Or make another complaint.
Perfection. Okay, so the OCR goes back 180 days. Is there ever a time if things are discriminated within those 180 days, but there were more issues before that? Do they go back further than the 180 days?
So there are people that are granted the waiver. I've never been one of those people, nor do I know anybody that's been granted a waiver over 180 days. It exists. I know it exists, but nobody that I know of has been granted. My understanding is if it's egregious, if you didn't have the ability to file, not you didn't know you could file, but you didn't have, I don't know, you're deployed. I don't know, you were deployed. You couldn't get access to I don't know. I was hospital. I don't know what those would be. It's never been granted for me. I've never asked for an extension outside of 180 days because I don't have really unique circumstances.
What happens if I forgot to add information on my complaint? I am in the process where I just booked a call for them to gather information.
That's a problem. So I might do one of a couple of things. I might, when I'm on the call, ask if I can add it to the complaint, or I might rescind my complaint and refile. That's totally your decision. It totally depends how many days you're in. Is it gonna make a difference, right? If I say they were mean to me on Thursday, they didn't talk to me in the car rider line, right? You really want to talk about things that are legal violations. There's a great hearing officer one time that told me that there are a lot of things that are wrong that aren't illegal. You have to weigh if I resend it, revoke my complaint, right? And then refile, you're going to get you're going to get somebody else. So there's another of different factors. So that's going to be your decision.
How long does OCR have to make a final findings for noncompliance? Is it 60 days, a year, etc.?
It's the last one. Usually they do their complaint once the notification is delivered to the recipient and the complainant. That's within 180 days, they're going to be investigating it. But a myriad of things could happen. The recipient of your complaint could ask for an extension of time due to a number of factors. Yeah. So there's not a set, it's not like a state written complaint where you're in and out in 60 days. It doesn't have those time frames.
All right, this is a really good question. If you're in a prolonged IEP negotiation process and it appears that the school is going to remain non-compliant, would you file anyways?
Yeah, I would. I don't find that people that are non-compliant after I've notified them just go, hey, I shouldn't do that anymore. I certainly am going to notify the district, hey, ABC school district, you don't have a certified teacher in a self-contained room. And then when they give me all this rigmarole about how they're fine with that, blah, 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 you're either going to change based on you're going to address that and fix that for my client that's a child with a disability, or you're not. You can figure that out pretty quickly. Either we're going to move and address what needs to be resolved, or you're not. And if you're not, I'm just going to file. I'm not going to go join on filing. I don't do that. But we're in several situations where I realize that this is not successful. I'm not going to just keep taking clients back to IEP meetings and we're just keep talking about it doesn't serve a child with disability.
This one says the sensory diet is part of my child's IEP. They removed the things he needed to regulate his body because the teacher said we were rewarding him. Where would the complaint be most effective, at the state or at the OCR? We're in Utah.
So I can't tell you where it'd be most effective because there's people involved called people, right? So you might get the world's greatest state investigator, you might get the world's worst federal investigator. But an accommodation is a civil right. So unless we had a meeting or a paper amendment and agreed to remove said accommodation, you have to deliver it, whether you agree with it or not. And I have that happen a lot. I will have one 4th grade and now the 5th grade teacher's like, he doesn't need that. That's not your call. There's civil rights. And a lot of times I will see in paperwork, I saw it today, teacher discretion. No. Your rights are not discretion. There's no discretion. So if we said he has access to a sensory diet and you denied him a civil right, it doesn't matter the why. You either delivered it or you denied it. And so I really want school-based members to know that. Either delivered it or you denied it, delivered or denied. So if you're very clear what you've made a decision, you might have even agreed with parents, he doesn't need the sensory diet anymore. Make sure you get the paperwork correct because we live and die on the paperwork.
Okay, so that was our last OCR centered question.
We'll see you in part 3. Hit subscribe, share this with a friend, and you know what? Meet me back here every single week. We're not just talking about change, we're making it. Because when you know better, you do better. And when we get it right for the child, we get it right for everybody.